to Disputes in Perspective, a Reed Smith podcast. This podcast series will discuss disputes-related trends, hot topics, and developments occurring in the global legal landscape, and hopefully provide you with some helpful insights and practical tips. If you have any questions about any of the episodes, please feel free to contact our speakers.
Welcome back to the podcast. I'm Adam Massaro in the Denver office of Reed Smith, and I'm joined by a special guest, Jim Martin. Jim, how are you?
Very good, Adam, and good morning.
So we've been at the new Denver office for a little over 6 months. How's it going for you so far?
I love being able to come into an office again. I was working from home primarily in Littleton before we opened, and it's nice to be back with colleagues in the office.
Now, a lot of us, like myself and my team, came over from another office, but you were actually at Reed Smith before we opened the Denver office. Is that right?
Yes, I think the firm actually dates my beginning started in 1978. So I've been here quite a while.
All right. Well, that's before I was born. So I think you can be sort of the holder of knowledge on this podcast then for the firm itself. How's that sound?
Perfect.
All right. Well, give us a little background. So even though you've been with the firm for a very long time, how did you get your start at the firm?
Yeah, so if we look at the California footprint, I was a summer associate in 1977 in a firm called Crosby, Heafy, Roach and May. And in 2002, we merged with Reed Smith. And at that point in time, I relocated to Pittsburgh as part of the combination. So my first Reed Smith office was in Pittsburgh in 2002.
I see. And why did you choose to go back east, even though you're in a West Coast office?
Well, I was either the hostage or the symbol of good faith. Yeah, you have to answer that depending on circumstances. But the combination was the largest domestic law firm combination up to that time. And it was so significant for both firms that we agreed a principal partner in each firm should go one west-east and one east-west.
Yeah, it sounds a little bit like a prisoner swap, but at least you got to go to a new location. So you went to Pittsburgh. What type of litigation work were you doing in Pittsburgh then?
Well, I had an appellate practice, still do, and that was important in the combination. Reed Smith wanted to build out a freestanding appellate practice. And that's what I started doing on the East Coast when I got there.
And for appellate work over the years, where are some of the different places you've briefed and argued?
Well, I've been in every federal circuit court and the Court of Claims. I've briefed and participated in cases in the U.S. Supreme Court. I've never argued there. I've briefed and argued in probably 9 or 10 state Supreme Courts and probably a similar number of state Court of Appeals over my career.
As trial lawyers, anytime we're in a different venue, there's obviously all types of local considerations, things like that. At the appellate level, though, when you're arguing one circuit, federal circuit versus another, how much do you factor in the locality, demographics, things like that at the appellate level?
I think it's very parallel. Just like trial lawyers want to get the lay of the land with local judges, appellate lawyers want to do the same thing. And there are frequently consultations with local appellate lawyers about Federal Circuit Court of Appeals and the judges in them, and State Court of Appeals and the justices in them as well.
I want to talk some of the mechanics on the appeals themselves, but let's start with the simple level. I've always heard you can't have just a pure appellate practice. Is that truth or fact?
I'd say it's somewhere in between. So you can have a pure appellate practice. I think you have to give it a proper description. And so the dimensions to a pure appellate practice, in my view, are more than just the straight appeals that you and I might understand after trial. It's a broader consulting practice and even involves trial work on some level in order to properly, I think, implement everything that appellate lawyers should be doing.
So the thing if I could unpack that example is obviously issues that aren't preserved, you can't argue on appeal. So bringing you in at least at the post judgment, motion for new verdict or reversal, things like that, minimum, but perhaps even earlier, if we're talking about a significant issue that's going to impact all types of future issues in the case as well.
Yeah, I think if you unpack my practice and look at the pieces of it, that consulting role is a significant one, particularly as I've gained experience in jurisdictions and in front of a lot of judges and courts. But issue preservation is one aspect of that. Strategic choices are another. And of course, there are opportunities to participate and support on major substantive motions. Daubert, for example, you would be familiar with class action, class certification. And the reason for that is those motions often carry interlocutory appeal potential. So you really want an appellate lawyer in the drafting process, even in the arguing process. And then that paves the way for appeal. On the issue preservation, it's the same thing. You don't want to leave behind anything that might create an opportunity for reversible error. So getting an appellate lawyer in the mix is important.
On jury instructions, there's just an area that I always see ripe for error for judges, especially they're always working on them towards the very end of the trial itself. These little time for really reflection. So I've seen all types of things, reversal of the improper burden of proof, improper instruction on a key element, too many instructions that I think are actually inappropriate. On jury instructions, though, if you're going to actually get a reversal, and that's the jury instruction, what are some of the things you need to focus on to actually establish grounds for reversal when we're talking about a jury instruction error?
Yeah, so let me back up and deflect that for a second. I think jury instructions are an important part of the consulting role that I play. And that can be on two levels. One, in helping define the factual investigation and discovery that's needed to prove a case on the one hand or defend it on the other. And then second, to make sure that the instructions that are given are either properly submitted or properly objected to. And I often appear in cases at the trial level at instructional conferences. For those purposes, it takes the burden off the trial lawyers and they can be busy preparing closing. On your point about where you get instructional error, it's probably the most frequent type of reversible error that you'll see in appellate practice. And I think the most significant errors come in the burden of proof or in ambiguity in instructions. You're going to have to show those are prejudicial at the end of the day. That's the standard of review. But if there's an error of law in the instructions, that's a pretty easy hurdle to clear, and that's why you see. But back to my other point, that if that instruction wasn't properly objected to at the time, that's going to impact the appeal for sure.
What that always focuses in on my cases is, if I'm going through the case and at some point I get a claim dismissed or I get a ruling on a pure legal issue, my initial reaction is good. If it has to happen, I'd rather have it happen on a pure legal basis or in summary judgment so I get the de novo review. Put differently, though, is there any circumstances where you've actually seen a non-de novo issue reversed? And if so, what are those non-de novo issues that actually can be reversed, that actually have a shot when you go up on appeal?
Yeah. So the non-de novo issue, I think that actually happens the most frequently is the lack of substantial evidence to support a ruling that was made, as opposed really to an abuse of discretion. And that can come up in a lot of contexts because there are a lot of pretrial rulings that require substantial evidence in order to support them. And when you unpack it, a lot of times there are only conclusions to substantiate a ruling, or the judge doesn't articulate the evidence to support the ruling. And when you unpack it, it's not there. Could be inconsistent with the proof offered. So I think those are examples of when you can actually get a reversal, even on a non-de novo situation.
One other thing I'm always thinking about at trial is what issues do I move at halftime, especially if I'm either the defendant or if I'm the plaintiff and somehow I think I'm actually holding some real cards, but mainly as a defendant. I think about what can I actually get out of a halftime motion versus what do I save for a post-trial filing. I will say, as I've done more cases, the one thing I definitely think more about is, do I have to bring this as a halftime motion or not? Example is oftentimes on a damages award, my reading of a lot of the rules is I can oftentimes challenge the damages award after the fact, especially if it's one that's based on, for example, a completely unsubstantiated lost profits analysis or something to that effect. But the other flip side that I always deal with is, well, if I move at halftime and I don't get it, I've also been tipped off the other side about issues they want to, potentially fix before the close of evidence. Thoughts on sort of drawing that line on what issues you think really need to be addressed at a halftime before close of evidence versus things you can save for after the trial itself?
So, first thing on that is you got to check your applicable rules in your jurisdiction. In federal court, for example, if you save anything, you're at risk. Federal preservation rules generally require a pre-verdict motion on anything you're going to move on post-verdict, and the waiver penalty is pretty severe. Some states adhere to that same standard on most issues related to everything but damages. And so the first thing is a preservation issue, not a tactical issue. On the tactics, I think it depends on how you feel about the education process that you mentioned. So if you assume you're in a non-waiver situation, and you see some risks in educating the other side, then you probably want to hold back. But there's another player in the education arena, and that's the judge. And oftentimes, I think the pre-verdict motions are intended to signal to judges just how weak a case is in any of its particulars. And that can help you post-trial, I think, when your motions come in, because that decision process is usually in a pretty compressed time frame. So some of that pre-verdict education can be important.
I see. One thing I've seen, especially the cases that do go on appeal, there's oftentimes at some point there's a significant switch in the judge, especially if we're talking about rulings by the court that then create a cascading effect. And sometimes you get judges where, in my view, once they make a certain path, they're going to go down. They're not going to move off of that. Have you seen examples where, especially when you consult early enough before you're at trial, or at least at trial, that you can actually get a judge off of that, or to actually grant a post-trial motion? And I'm curious how you sort of stop that judge slide, because when they start going down a path, it seems like it's very difficult to get them off that path as they move forward.
Yeah, I think there's two pieces to that. One is diplomacy, and then the other is the substance. Diplomacy is just a code word for the fact that judges have an irritation factor if you're constantly reminding them about issues that you think are important, but they have in fact run the case off the rails. So I think packaging is very important, but I do think in the course of the trial, it is also important to come back to questions of prejudice that relate to the way the proof is going in or the issues that are being considered. Again, looking ahead to your record for appeal. In my experience, it's similar to yours. Judges don't have an epiphany very often where they come around, but your chance of getting that epiphany is a lot stronger if you have diplomatically at stopping points during the case, even in chambers conferences, make sure they get on the record, reminded the judge that this is really prejudicial and impactful. And I have seen courts turn around with that kind of record in front of them, but it doesn't happen very often.
Let's flip to the actual appeals itself. So when you're taking in an appeal, the one thing I always question is how do you take an objective viewpoint when you're being hired by one side? You're being hired to either reverse the outcome, affirm the outcome, but your focus is on that side, and the story is already told on some levels. But at the same time, you want to be careful. You need to keep the evidence that you can argue up on appeal. But at the same time, you don't want to have that confirmation bias or be in a position where you're only making opinions based off of what was argued below. How do you have that fresh reset so that you are coming up with what you believe are the best winners on appeal, even if what everyone thought below was a winner, you don't even believe that should be the case up on appeal?
Well, I think that your experienced appellate lawyers have built up that objectivity discipline. And if you're going to be retained, even in cases within your firm or outside it over time, you have to display that. If you don't, I think you're not delivering everything an appellate lawyer needs to. And that can include, to your point, advising a client or a lawyer not to take the appeal, or at least to be candid about the chances of success on appeal. I think a lot of trial lawyers and clients look at appeals as rescue missions where suddenly three judges will see the light where one judge or a jury didn't before. And that's really not the proper equation. Affirmance rates are high. It's difficult to get a case turned around. And the objectivity, I think, first that an appellate lawyer brings to it is a candid assessment of the likelihood of success. After that, the principal problem you face is trial lawyers and often clients don't want to let go of issues that have been their significant card throughout the case. And oftentimes there's going to be no traction on those issues on appeal, and getting people to move off those is again, part of the objective analysis. That would also be lastly coupled with the objective reasons why certain issues make sense to raise on appeal and why it's worth spending the money on it. And I think if you don't have that, as I said, your career as an appellate lawyer is going to be relatively short.
I always hear you come up with your best three arguments, pick them, live with them, and lean in. Can you have more than three? And how do you have that sanity check to know how many is too many on appeal?
Yeah. So you could probably do your sanity check at more than one, right? Because it's very, very difficult to say that, there are multiple issues in a case that create reversible error when candidly, reversible error doesn't happen very often. So you've got to be very careful about the number of issues raised. I don't think there's any litmus test. There can be strategic reasons to come at appeals with several issues in them if you manage it properly, to try to indicate the level of prejudice that occurred, even though the court's unlikely to gravitate to the last two or three of those issues.
I see. And last question. you've been practicing for decades. Live advice, but what's the one piece of advice that you would tell yourself that you wish you would have known?
I think I wish I would have known how to do a better work-life balance over my career. If I had it to do over again, I would have been more careful about the amount of time I invested in the practice at the expense of paying attention to some other things I should have. I ended up as a better lawyer as a result of that, but I think I could have gotten to the point where I am as a lawyer now and having invested a little more time in other endeavors along the way.
Well, it's an interesting observation because I think you won't know if you're a good enough lawyer until you proved it, and how you can make that calculus under the circumstances is tough. But it sounds like at least you've confirmed that you haven't solved what is the same mystery that we've all been trying to solve, as you mentioned, in the private practice and beyond.
Yeah, well, I hard to argue with that.
All right. Well, Jim, thank you for your time. It's great to have you in the Denver office and excited to see what happens next, and excited to work with you on appeal as we go forward at some point, one way or the other. But that's it for our podcast today, and thank you for joining.
You're welcome.
Disputes in Perspective is a Reed Smith production. Our producers are Allie McCardle and Shannon Ryan. For more information about Reed Smith's litigation and dispute resolution practice, please email disputesinperspective@reedsmith.com. You can find our podcast on podcast streaming platforms, reedsmith.com, and our social media accounts at ReedSmithLLP. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.